Trust protection. What gives us no protection in a trust? No asset protection other than this T by E that I was describing. A revocable trust provides no protection. And also, if you create an irrevocable trust in a state that does not have a domestic asset protection trust statute, like Maryland, so you contribute assets to an irrevocable trust, have a third-party trustee in charge of it. Your creditor still can pierce through it because it's your assets and you created it and it's for your benefit. Self-settled means I put assets in and I can get assets out for my benefit. It might be health, education, maintenance, and support. Somebody else may be administering it, but it's a self-settled trust. If it's for somebody else's benefit, that's a third-party trust. And if you have a third party serving as trustee, then the answer is different. So we may have real asset protection over assets we put into an irrevocable trust with a third party trustee for the benefit of somebody other than me or you. That gives asset protection. What is a domestic asset protection trust? It started in Delaware, Alaska, Nevada. Now Virginia has a statute. There are 16 states that have domestic asset protection trust statutes. Lots of questions remain around these statutes. Where are the assets located? Who is the trustee? Usually these types of trusts require that you have a third-party trustee, you can't be the trustee, living in the state in which the trust is created. So in Virginia, you must have a Virginia resident trustee. And then the question is, where are the assets located? If it's real estate in Virginia, that's an easy answer. It's going to be covered under the statute. But what if the assets are located in an offshore bank account in the Cayman Islands? Is it covered? So the law is very unsettled in this area, and it's being challenged in courts by creditors, and we can't give definitive answers. Of all the literature I read on this almost daily, the cases are evolving. There's some protection in some jurisdictions, others don't afford any protection. But the general rule is you use these to protect assets that will escape claims of creditors. So there are no claims outstanding against you today. You can put it into a self-settled asset protection trust in Delaware, in Alaska, in Nevada, in Virginia, with an Alaska trustee or a Virginia trustee. But then you have to be sure that you're not subject to one of the exemptions under the state statutes. For example, bankruptcy law says the trust has to have been in existence for 10 years in order to escape the claim in bankruptcy. So if you've held the asset in a domestic asset protection trust for at least 10 years and then go bankrupt, it is protected from bankruptcy creditors. Lots of exemptions. Usually they focus on child support. That's exempt from the protection of the self-settled asset protection trust statute. So if there's a child support claim against you and you try to set up one of these DAPTs, you're not going to succeed. They'll pierce it and they'll be able to collect it. Questions?
What about grantor trust, like those defective grantor trusts where you are the trustee of an irrevocable?
So let's say I set up a trust like we're going to do in one of our examples coming up shortly. Let's say I set up a trust and it's an intentionally defective grantor trust, meaning that I'm doing this for estate planning purposes but not really for income tax purposes. And I remain the trustee. What's wrong with that picture? You shouldn't be the trustee. It doesn't work. It won't be effective. It'll be intentionally defective for all purposes. And if you're the trustee, by the way, your creditors are going to be able to pierce through it and get it because you have discretion over the trust assets. But if you put a third party in charge of it, and then maybe your spouse as a co-trustee, you might be able to achieve asset protection. So the characterization as a grantor trust is a tax designation. The characterization as an irrevocable trust is part of the puzzle. And then the other question is, who's the trustee Who's the beneficiary and what powers does the trustee have? Those are the things you're focusing on in determining how much asset protection you'll enjoy. Okay? Spousal planning, whether it's a marital trust or a credit shelter trust, if you're concerned that your surviving spouse is going to divert the assets to a new spouse and away from the children or what your designated estate plan was, the safest thing to do is to put a co-trustee or a trustee over those trusts that the spouse has to communicate with and interact with. And if you have that type of a relationship, and if it's an independent third party, it does make it more difficult for the spouse, but it does provide asset protection. If the spouse is the sole trustee and the sole beneficiary or the primary beneficiary, the only person that's going to sue the spouse is the child, or a guardian for the benefit of the child, and they may not know what's going on until it's too late. But most of my clients who are married, who have good marriages, don't mind having the spouse, surviving spouse, serve as the sole trustee. But we do put in often the provision that talks about remarriage. So if there is a remarriage, should there be somebody else serving as a co-trustee? Should there be a prenuptial agreement with the new spouse? What is your plan? And in all states, common law marriage doesn't exist, but where it does, that raises other issues. Palimony issues. I mean, so how do you protect the assets? How much are they? How do you protect these assets for the benefit of the future heirs after the spouse dies? If it's not, if it's $1 million or less, that may be enough for the spouse to live on the rest of her life anyway. And you want her to be able to live, or him to be able to live comfortably. So we'll provide more flexibility in that kind of situation. But if we're talking about $15 or $20 million or $100 million, we definitely want to talk about additional protections. Now, again, in relationships where the spouses are really tight, they trust each other to do the right thing. And that's usually the answer that we get. I trust my spouse. He or she will do the right thing. So I don't care if it's $1 billion, she can be in charge of it by herself. It's a tough discussion that we have, but we do have these discussions. And then for descendants, keeping the assets in trust helps your kids protect themselves in the event of a divorce. So let's say you don't want to control your kids from the grave. You want to allow them to protect themselves in the event of a divorce. So you let them keep the asset in trust, and they can serve as their own trustee. It doesn't give them creditor protection other than in divorce, but it will give them divorce protection in most states, except for Colorado. I don't know why Colorado's like that. And then you can build in other protections to allow for the assets to remain in trust for future generations, but still have access to it for their needs. And the question is, how do we design these? We may put in conservative guidelines that limit the discretion of the trustee as to when they can make distributions to the children, as opposed to just giving it to the children outright. If you give an asset to the child outright upon the death of the surviving spouse, then they can do whatever they want with it. You can't put conditions on it. If you leave it in trust and you have provisions in the trust that guide how the assets can be used, then you can put limitations on it. So, case study 1, single member LLC. Jack wants to start a new franchise using his retirement savings. What's the red flag that just went off in your head as a financial advisor? Using retirement savings. He can invade his retirement, but if he's under the age of 59 and a half, he's not only going to have to pay income tax, he's going to have to pay an excise tax on the withdrawals. What about all these schemes that you've been reading about where they say, why don't you just take your 401k, start up a new business, and just roll it over into the new business 401k and have it invest in the business? Or why don't you just have the IRA invest directly in the business? What's wrong with that? Fiduciaries in this room. Amanda? What's wrong with it? There are rules under ERISA and that apply to IRAs that prevent you from using these assets for prohibited purposes, prohibited transactions. So the prohibited transaction rules actually, and jeopardizing investment rules, which apply for fiduciaries to understand these rules, you have to study them. But you shouldn't be using retirement savings to start up a business. Period. I don't care what you're reading on the internet. I had a client come to me and they said, "Oh, I've read about this, and this outfit's helping us structure our arrangement, and they'll even do the incorporation for us and set everything up." I said, "Okay, you're no longer a client. I don't represent you anymore because I told you not to do it." Yeah, but it works. Not if the IRS audits you. It doesn't work. It's under scrutiny. It's also one of the dirty dozen transactions that the IRS is after. So they don't like this. Okay, outside of that, it's a single member LLC. He does everything right, but then he has to go bankrupt. I can't promise you that it's going to give you unlimited protection as a single member LLC. So the advice here to Jack is do not use your retirement savings. Number two, have another member, even if it's your spouse. But doesn't that make me have to file a separate tax return for the LLC? Maybe. But it's two members. In the case, there are no cases yet that have come down to pierce a two-member LLC, in bankruptcy or otherwise. None. LLCs are new creatures of the law. They only came into existence in 1987 in Wyoming, and in most states in the mid-90s and late 90s. So they're new creatures. But in the corporate world, we know what they do, and thin capitalization and following the formalities are the important factors that the courts use to figure out whether or not to pierce through a corporate veil. We assume that they're going to use the same kind of analysis here in LLC. Any questions? Case two. Husband wants a divorce, so he transfers 2/3 of his assets, thinking that 1/3 is still available to the claims of his spouse, to an irrevocable trust for kids from a prior marriage. Wife doesn't know or consent. He's contemplating divorce. Is there a claim? Potentially. She has a potential claim to all of his assets. She has a potential claim to half of his assets for sure. So it could be unwound in a divorce proceeding. So if he's doing it for tax planning, best thing to do is to disclose and get consent. You do this with charitable trusts as well. Get the spouse to consent. All right. We've been through this throughout the boot camp. The exemption's $5.45 million. The maximum tax rate's 40%. You can only give away per donee $14,000 per calendar year. And of course, we now have portability of the unused exemption of the deceased first spouse. So you get to file a Form 706 to get that portability, but it's available. It's a lot more flexible than it used to be. It doesn't mean we should rely on it exclusively in our planning, but it protects us if we forgot to do any planning.
When do you have to do